Okay, hello everyone. My name is Mehmet Yaya. I'm the department head for the economics at Eastern Michigan University. And today we are pleased to have Judy Keenan from Equal Employment Opportunity Commission, New York District. We are going to have a brief introduction by the Women in Economics Club, who co-sponsors this event. And Marcy is going to do that presentation, I believe. So I'm going to let Marcy briefly present Judy for us.
I'm not hearing.
Marcy, we don't hear you right now. Can you unmute yourself?
Oh,
Thank
sorry
you.
about that. Can you hear me now?
Yes, we can.
Okay, sorry about that. Okay, first of all, I just wanted to welcome everybody. I know that today is election day, so it's a little bit of a crazy day. Really wanted to thank everybody for being here with us. We have a special guest today, Judy Keenan, who is director of the EE, or the Equal Employment Opportunity Commission in the New York District. Just some brief background about Judy is she's actually a Eastern Michigan graduate. She graduated in 1980 in economics, which is amazing to have a fellow Eastern Michigan economist back here. And she also went on to Wayne State to get her jurist. And afterwards, she went on to work for a law firm company and Johnny Cochran's New York firm at the Schneider, Kleinig, Weitz, Damashek, and Shute branch. And in 2001, she formally joined the EEOC as a supervisory trial attorney. And as of 2020, in June, she was named the new director of that branch. So she actually serves in the New York District, and it focuses on combating job discrimination in all of New York State, New England, and Northern New Jersey. So quite a big branch there. I would like to give it to Judy to just formally introduce herself as well.
Hi, so I'm Judy Keenan, and I am the director of the New York District of the Equal Employment Opportunity Commission. And we are the federal agency responsible for enforcing all of the federal laws that prohibit employment discrimination throughout all of New England. So I'm responsible for enforcing laws pertaining to 22 million private sector employees. That's people who work for private corporations, private businesses, and state and local governments. And then for about 3 million federal employees in our district. And I'm really happy to be speaking to folks from Eastern because I loved my experience at Eastern. So it's really an honor for me to be able to talk with all of you today.
Thank you very much, Judy, for being with us today. As Marcy said, today is the election day, so this is a Alumni Corner webinar, and we would like to learn more about your experiences, how economics has helped you throughout your career, and then job-related questions. What do you do in your position as a director at the EEOC, and maybe give an overview to our students on that. That would be greatly appreciated.
Great. So when I went to Eastern, I knew that I wanted to be a lawyer when I graduated, and most of my peers were doing political science, sort of pre-law programs, and I was really not interested in doing that approach. I started off as a business management major, and I just wasn't that engaged with it, so I switched business management to be my minor, and I picked economics to be my major. And at the time, Eastern had a formal labor studies program. And since we spend so much of our waking hours in work every day, that was an area that was of interest to me, because even as a student, I had to work my way through college. Sometimes I had 3 jobs while I was at Eastern. So, given that work is just so much of our life, it's always been important to me that people have meaningful work that pays well and that people are treated fairly. So I really thought I was going to do some more union type stuff, union management type work when I graduated. When I went to law school at Wayne State, we had a really bad recession and jobs were just horrible. And I happened to get a job at a personal injury law firm while I was in law school, because I still had to pay for law school by working my way through law school. And it just so happened that another Eastern Michigan University graduate was in my law school with me and was clerking at that law firm. So I'll talk a little bit more about networking and the importance of networking. She and I had been in student government together. I was student body president for 2 terms at Eastern and very active in a lot of student organizations. And I learned, I have to say, every bit as much by being active in student organizations as I did in the classroom. When you go out into the work world, it's always about how do you put theory into practice. So the theories that you are learning in the classroom will absolutely be important for you later on. And I stayed in the personal injury field for 17 years. And there came a point in time in my life, and I worked in Detroit at first, and I always wanted to live in New York. And there came a time when I said, if I don't go to New York now, when will I do it? So I moved to New York in the late 1990s and started working for personal injury firms there as well. And then there came a point in time in my life where I said, well, I always said I wanted to do labor and employment law. And if I don't do it now, when am I going to do it? And I started applying for jobs, and I never thought I would work for the government because I had only ever been to Washington, D.C. for protest marches. But I applied for a job during the Bush administration, Bush 1, and I got hired at the EEOC, and it was also because of a networking situation. And then I actually had to start using my labor economics background to help me in the role at the EEOC. I will say it also helped me in my personal injury career too, because so often people who are injured can't work, and you have to use labor economics to value the damages that they suffered because they are not working. So what is the value of their lost pay, for example? And even home economics you have to do. If for example, a mother dies, what is the value of the services that a mother who might not have been employed outside the home to her family, and how do you value that? So I have actually used my economics background throughout my career as a lawyer. I am now no longer working as a lawyer at my agency. I am a member of what's called the Senior Executive Service, which is the highest level that you can get in the federal government as a civilian, just below cabinet level positions and the vice president. Our agency is a law enforcement agency. I actually have a badge which designates us as a law enforcement agency because we enforce laws. We don't have criminal penalties. We have civil penalties for the laws we enforce. And the Senior Executive Service is the civilian equivalent of being a general or an admiral in the armed forces, or being a career ambassador. So it is the highest level you can reach. And I certainly never expected that this is what I would do when I went to Eastern. I was going to be a lawyer, I was going to be a litigator, but I was going to be doing labor negotiations. I was studying labor negotiations primarily in my labor economics program. And I hated statistics, but and calculus and linear algebra, and all of those fields are very important to the work that I do. So what do I do now? I'm in charge basically for managing our programs to prevent and remedy unlawful employment discrimination. And we do that by educating the public and employers about rights and responsibilities. So that education and outreach is the first thing we do. The next thing we do is we investigate claims of discrimination that are filed with our agency or that we start ourselves because we have learned that discrimination exists. And then the third thing that we do is if we find that a violation of one of our statutes existed, then we try to get the company to come into compliance either through voluntary means such as a settlement, we have all these government names for things. So we have a process we call conciliation, but then we do mediation. So we try to settle it with them. And if they don't settle the case with us, we can bring litigation against them in federal court to have a federal court force them to come into compliance with our statutes. We don't file that many lawsuits, and most people who come to us, even if we find a violation of our statute and we don't institute litigation, we give them a right to sue, and they have a right to go to court on their own. So what are the laws we enforce? We enforce laws prohibiting race discrimination, color discrimination, national origin discrimination, religious discrimination, sex discrimination, which includes pregnancy discrimination and also LGBTQ discrimination. We have found, and the Supreme Court agreed with us, that if you discriminate against somebody because they're LGBTQ, that is discrimination on the basis of sex. We also enforce statutes prohibiting disability discrimination, age discrimination for people who are age 40 and over, genetic information and genetic information discrimination. And I also want to encourage you, if at any time you have questions, interrupt me. You can there's not a lot of people on this call, so feel free just to ask me a question, unmute yourself. If you really want to raise your hand, but I'm from a big family with everyone always talking at once, so I will feel more comfortable if you ask me questions at any time during this.
Judy?
Yes.
I have a question.
Sure, go for it, please.
Do you do any work regarding pay equity?
I do. And that would be under all of the issues that we cover. We see it, the very first statute that was passed by Congress in 1963, before we were even founded, was the Equal Pay Act, which deals with women getting paid equally to men for doing the same work. It's a very difficult statute to enforce. Title VII of the Civil Rights Act was passed in 1964 and also covers sex discrimination. And it's actually easier to prove a case under Title VII. And these are actually cases where economics becomes crucial to what we're doing. And it's also an area that continues to have a lot of controversy associated with it. So for example, women have to, under the Equal Pay Act, women have to be doing the same job in order for there to be discrimination. But what we find more often is that there is job segregation. Women are not necessarily placed into the same jobs when they're hired. And there still is a lot of job segregation where women are placed into certain jobs, men are placed into others, and then they go on to different career trajectories where men end up getting promoted to higher positions. Women go on and don't necessarily get the same opportunities. And then if women leave the workforce, then the pay inequity is often compounded. We do a lot of pay studies. So statistics are definitely used in pay studies. For a while, the EEOC was asking employers to do pay studies and report those to us. We have reporting requirements for companies called EEO1 reports, where they have to already report by race and national origin, the percentage of people who are in different very general job classifications. And then we had added a requirement that there be pay studies done too. That is no longer being done. There were some problems with whether or not those particular pay studies we were asking them to do could actually be used to show anything, or were they too general? So that's an area that even went through the courts, and we are examining it again of how can we have companies do studies to see whether or not there are pay disparities within their company or within their industry. Did you have any other questions you wanted to ask in particular about that?
Well, my question was just basically what is the EEOC doing to promote pay equity? So.
Yeah, so that is definitely one of our priorities. We have 6 strategic enforcement priorities that we're focusing on, because we have less than 2,500 employees nationwide. to enforce our statutes. And I already told you in my district alone, where I have 79 non-lawyer employees, there's over 22 million private sector, so we have a lot of work with not very much staff. So we've made a couple areas that are strategic enforcement priorities, and equal pay is one of our priorities. So, and we definitely have some suggestions for companies on what they can do to make sure that there is pay equity. And one is to do their own pay studies to see if women, what are men and women paid. We also ask them to look to see and these are statistical analyses that are being done. Are women being pushed into certain jobs and men pushed into certain others? And for that, you also have to look at what the labor market is and the labor market pool and what the availability is. So if women aren't studying XYZ fields, then a company can't be held responsible if in fact women are proportionate to the women in your company are proportionate to the women who have studied that field, then there won't be discrimination. And that's where pipeline programs become so important, and industries getting involved with getting women into STEM, for example, the whole STEM programs, because that is an area of great gender disparity as well as national origin and race disparity. So pipeline programs become important. They are not mandated by our laws, but they certainly are helpful best practices that companies can get involved in if they care about fighting gender and race discrimination. Another area that can be problematic is if companies are basing pay based on salary history. Then what can happen is that you can continue the effects of discriminatory practices. So if women were paid less than men for certain reasons, and you're asking people, what did you get at your last job? And the women were being discriminated against at the last job. You're just going to keep perpetuating that discriminatory pay system by asking questions about salary history. Our statute does not specifically prohibit companies from asking about salary history and using that as a negotiation tool. But if it had a disparate impact on it, it could be facially neutral because people say, we want to pay what the market will bear. But if it has a disparate impact on women, it might be illegal under our statutes. So that would be a statistical analysis. So you'd have a policy which on its face is not illegal, but if women are consistently being paid less than men because of that policy, you might have a violation of Title VII sex discrimination. And the same would hold true if they're for doing pay disparity based on race, color, national origin, or religion. So those types of labor studies become very important in deciding whether or not there's pay disparity. Recruitment policies. We also take a very hard look at what types of recruiting policies do companies have. Are they only and this, for example, like age discrimination cases. If somebody's posting a job for recent college graduate, does that have an impact on people who are age 40 and over, who might also be qualified for the job? And there are statistical studies that show that people who are over the age of 40 who get laid off from a job have a much more difficult time finding a job than people who are younger than the age of 40. So are there job postings that say things like recent college grads or people with 4 to 7 years of experience? Are they discriminatory or not? That's a hot topic in our area. They're not per se discriminatory, but does it have a disparate impact on people over the age of 40? That's where the statistics would have to come into play again, as well as labor market availability. So we actually employ labor economists at the EEOC. I was hired as a lawyer, as a litigator. I was not hired as a labor economist. I had not used labor economic skills, but we had in-house labor economists that we use, that we would have analyze these these things for us and help us ask questions of employers when we were investigating cases. And when we went to court, we would hire labor economists and statisticians to be our experts in the case. So it certainly helped me that I had taken courses at Eastern on this, even if they were a million years ago, because the vocabulary was at least somewhat familiar, and I was able to pull out, the more recent books, because everything changes, but there are still certain things that stay the same. And that was very helpful in knowing what questions to ask that would actually be relevant to the case, as well as cross-examining the other side, because as all of you academics know, there are many ways to look at a question. And when you're litigating a case, the different sides they will ask different questions, and they will look at the questions very differently. But knowing what all of those potential questions are, it's very helpful if you come to it with a background already. So whether you want to come and work for a federal agency as a labor economist, or we also hire investigators, who frequently are people who have the bachelor's degrees or master's degrees in all kinds of things, whether it's industrial psychology, economics, political science, any of the liberal arts. Those are the kinds of people with analytical skills who we would hire as investigators for our agency, to ask these kinds of questions, because when we're looking at broader questions of discrimination, it's we certainly look at the individual case. Was this particular person paid less than a specific, let's say, was this woman hired and paid, let's say two people were hired at the same time, a woman and a man, for the same job. We would certainly look at what was their starting salary, and if one is paid higher than the other, that becomes pretty clear evidence. But then you're also going to look at, is there a broader problem at the company? And that's where the statistical analysis also comes into play. And you would also look for evidence of, are there people making comments that might be, for example, age bias comments or color bias comments, or we have cases where people have said things like, well, a man has to feed his family and the woman's just going to leave the workforce anyway, so we need to pay men more to keep them working for our company so they don't go work for somewhere else, but women don't care about getting paid. I mean, we have cases where people actually say stuff like that when they make decisions. So that's definitely an area at issue in cases. But we also look at economics, not just for pay disparity cases, but even harassment cases. We would use economic analyses, mostly the statistical portion of that, when we're looking to see, is there a broader pattern or practice of sexual harassment in a company? We have done very broad-based sexual harassment, and that's another one of our priorities, is harassment in general. And what are the kinds of things that we can do to see if there is harassment? We know that people are afraid of reporting harassment because they fear retaliation, or they think that they're going to be blamed for causing the harassment. So that's where folks who have survey backgrounds are very helpful, because there can be, companies who care about preventing these problems can set up anonymous survey of their employees to find out what are workplace conditions like, not only in terms of harassment, but also just in terms of treatment in general. So anonymous surveys, exit interviews, designing exit interviews for people. Why are people leaving the company? Finding out what it is about the company that is making people leave to go somewhere else. And that's definitely an area where labor economists or people who are in the HR field can get involved. There are state and city laws that are also used to fight employment discrimination, and often they are broader than federal laws. for example, in New York City and New York State, the laws are much broader. Their age discrimination laws cover people regardless of age. So if people were not being hired solely because they were younger, but still met, minimum age requirements like being an adult, there could be discrimination in New York on that basis. And some other kinds of cases might be easier to prove as well under some of the city and state laws. Michigan laws, I'm not as familiar with anymore because I've been in New York for 25 years, but Michigan law in general had been broader than some federal law. So, people can go there as well. Did anyone have any other specific questions that they're really interested in learning about in terms of economics, labor economics, the HR field, and discrimination?
I have a quick question.
Yes.
So can an employer force or take time to say that you can change your jobs or take time off if you are pregnant? And if so, then how this will affect your company to look after that?
So there is part of Title VII sex discrimination law was amended by the Pregnancy Discrimination Act. So you cannot discriminate against somebody because they are pregnant or giving birth to a child. And basically you would have to treat women who are pregnant like you would treat other people who have short-term disabilities. So if you're giving other people sick leave, then you would have to give women sick leave. There are some states which have specific requirements. There's also the Family Medical Leave Act, which would apply to this situation, which my agency does not enforce. The Department of Labor enforces that particular statute about leave under the Family Medical Leave Act. We would, however, look at it in terms of how they're treating other people. And if you have a pregnancy-related complication that requires you to take more leave than just normal pregnancy, it's possible that pregnancy-related complication would be a disability under the Americans with Disabilities Act, which we enforce. And under the Americans with Disabilities Act, an employer must give an employee a reasonable accommodation if that reasonable accommodation will let them work. And sometimes giving leave as a reasonable accommodation is required under the Americans with Disabilities Act, because it would, if they took off X amount of time, it would allow them to come back to work later. The reasonable accommodation can't cause the employer an undue hardship. If it cost too much money or really disrupted the employer's business, then it would not be considered a reasonable accommodation under our statute. So it's a convoluted way of protecting women who are pregnant under our laws, but there are those protections under the laws we enforce, as well as the Family Medical Leave Act. The other thing that happens is that if it's a reasonable accommodation under our statute for leave, then the person would have to be allowed to come. So let's say somebody developed a very severe pregnancy complication, maybe preeclampsia, and had to take significant time off from work. Under our statutes, they would have to be returned to the same job when they came back. Under the Family Medical Leave Act, they would have to be returned to basically a substantially similar job. So there are some differences in the way it plays out depending what statute gets enforced. It's a great question.
Another thing is that will that leave will be paid leave or unpaid leave?
Under federal law, it's unpaid leave, unless you're giving paid leave to people for similar conditions that are short-term disabilities. But our laws do not require that it has to be paid leave. You would probably have to let people use their vacation for that type of leave, which then would be a form of paid leave. But if vacation time ran out, our laws do not require that it be paid leave, which is different than what some other countries do.
Judy, I have a quick question, if you don't mind.
Sure.
I was just wondering your opinion on the effects of unions in the equal employment opportunities. As Michigan, as well as New York, have significant presence of unions, but declining. What's your take on the historical role of unions in these equal employment opportunities? And with the decline of unions, do you see more cases in your district or in general in the United States?
Yeah, well, it's funny because my dad was a General Motors executive and my brother works for an auto parts company where he's the local union president. And my father always used to say, don't screw up my retirement by suing General Motors. So, I mean, it's always been a big joke in our family because we have all sides represented. And I have been both a union vice president at the EEOC because employees there are members of a union, and I'm a member of management. And it cuts both ways. The civil rights movement certainly is responsible for advocating for civil rights and for workplace protections in general. So I think every major workplace protection that we have enacted by law in the United States, the labor movement was very was a very big proponent of getting that statute enacted. We have had a number of cases at the EEOC under all the statutes we enforced that were brought to our attention by a union. So, for example, one of the cases I worked on was a disability case against Verizon, where they had a point system for people who were absent or late. And once you racked up X number of points, you would be disciplined or fired. And what happened was they weren't taking into account whether your absences were due to a disability covered by our statute. And they were giving people okay if like you are on military leave or if you are on jury duty, but they weren't giving you a reasonable accommodation under the ADA when they applied that statute. So we ended up investigating that case, and we worked with the Communication Workers of America. They were one of the groups that brought the problem to our attention. And as a result of that case, we had a $20 million settlement against Verizon, as well as a requirement that they change their policies and actually start taking a look at people with disabilities to see whether or not they were entitled to leave and shouldn't be penalized by this point system. So we've worked with unions. We've also had some pregnancy discrimination cases where certain benefits were paid to people who had other disability issues, but it wasn't covered by the, pregnancy related complications weren't covered by the employer's insurance policy. So we had, and that was another case that was brought to us by a union. We have also seen lots of cases where unions can be the problem. There are, unfortunately, some corrupt unions out there where in order to get into the union, it seems like you have to be the son of somebody who's already in the union. It's a pretty notorious problem in New York, at least, and in the construction industry, where you will see, this particular local union is a whole bunch of Irish guys because it's a job that gets put on from father to son. In another place, it might be a different ethnic group. So, and certainly in the construction industry in New York, there's been a huge problem where Blacks in particular, were not able to break into the union. And if they couldn't get into the union, they could not get hired to work on the job site. So we actually have sued the union in cases like that, so that they have to start following our law and have equal employment opportunities as well. But certainly unions have been and the labor history in Michigan is very different, but the UAW in Michigan, even though it's had its issues as well, was at the forefront of passing the Michigan Civil Rights Act, which was passed around the same time as the Civil Rights Act of 1964 federally. So it's a mixed bag, and certainly union contracts can provide much broader protection for employees than our federal laws can, because then becomes a matter of contract, and then it becomes a grievance. But the enforcement provisions are different. So if a union contract is violated by an employer, we certainly would have nothing to do with enforcing that. But if a union brought a discrimination problem to our attention, that can be very helpful to us as a law enforcement agency.
Thank you.
Any other questions?
I think I actually.
Yeah.
Yes.
Go
Lisa,
ahead.
Lisa, I think you had a question.
Okay. Yes, Judy. I have a question. I have worked in the manufacturing sector for many years, and I'm doing a career transformation and going into healthcare. I'm curious about the amount statistically. What sectors do you find the highest rate of sexual harassment? For example, manufacturing versus healthcare, you know.
So
I mean,
I'm not an expert on that, but I can tell you that we have a report that might address some of that on our website. If you go to www.eeoc.gov, we have a select task force report on harassment, where we had experts from all different fields talk to us about the problem of harassment, sexual and otherwise, because racial harassment, national origin harassment on all of our statutes is a huge problem. And this report was issued 1 year before the Me Too movement happened. And our report basically said what we've been doing as a country has not been working. So we need to start taking different approaches to preventing and remedying harassment. There certainly are industries where harassment is a very big problem. And I do know that what our report says is that if an industry has tended to be homogeneous, in other words, if an industry has tended to be of one race versus another, or one gender other than another, when people outside of that culture come in, there tends to be a higher rate of harassment in those types of industries. So that is, so if it was, for example, a male dominated industry and women are coming in, then it tends to be something where you would see sex harassment. Similarly, if it was an industry where it was one race or national origin, and somebody from a different race or national origin comes in, then you tend to see harassment. And we see it, where it could be one Hispanic group harassing people from a different Hispanic country. We see that kind of harassment, on many different bases. We see disability harassment, we see age harassment, and that's why, if workforces are homogeneous, harassment is a much bigger problem for the quote unquote outsiders than if there's a broader pool of employees to begin with. Was there another question? And did that answer your question, Lisa?
Yes, thank you, Judy.
Okay.
So we actually have kind of a split group in here, which is great, because we've got the economics side, which the majority is, and then we also have some business and human resources people in here as well. Right. That's my two majors, so we just kind of extended the Zoom meeting. So I think this is really great, both the economics portion and the human resources. One of my main questions is something that really stuck out to me that I actually had a professor from our school tell us, was that when he started off in kind of like a managerial HR position, he actually worked for a company in Canada where he witnessed one of the hiring managers basically have 2 or 3 candidates at the table. One of the candidates was clearly better than the other 2. However, she was a woman in her late 20s. And what he said was the main boss who made the hiring decision basically said that he did not want to hire her because he was assuming she would go on maternity leave or be starting a family very soon. So this is kind of a form of covert discrimination that happens a lot. And despite this teacher being male and completely not agreeing with it, he's at this point underneath this person who is instilling these values into the company. So I guess my question would be, as future managers and human resources specialists, when we see something like that, that clearly does not align with the Title VII laws and also is morally incorrect and facilitates discrimination, what would be the next step to go about?
That's a great question. And I don't know if you have a student chapter of SHRM, the Society for Human Resource Management at Eastern or not, but that is the professional society for human resource people. We do a lot of work with SHRM in talking to their membership. A lot of the training we do helps give them their continuing education credits for SHRM. It is illegal to do something like that in a company, and we see it far too often. So one of the things that needs to be done is leadership has to come from the top. There has to be this culture of believing that having the best qualified people is what's important at the company, and getting away from stereotypical notions that certain people may or may not leave the workforce. One of the things that's changed dramatically since I entered the workforce is the whole concept of parental leave. It used to be maternity leave. Only women took time off for child care. And, more and more men are now getting involved with it. So progressive companies have parental leave policies where men and women both are able to take time off to help raise children from infancy and also to help raise children and care for children at other times during life. And people are finding that it's a very beneficial thing to do. And people are also finding that, bringing people back into the workforce who have been out on other kinds of leave, it helps people to have more creative thinking. So this, we like to say that following our laws is good for business. It will ultimately make the company work better, and it's certainly less expensive than a lawsuit from the EEOC or from somebody, a class action lawyer who's bringing the lawsuit. So, we encourage everyone to take a look at what are your recruitment policies and procedures and what kinds of decision making is done. And also even in evaluations, how are you awarding your executives for making decisions? When their performance appraisal is being done, do they get awarded for having workforces that are a broader workforce? Are they penalized in their evaluations because discrimination problems occurred that they didn't properly address? How proactive is the company in training its executives about what is and is not illegal, as well as what is or is not a good business practice for profitability? Those are the kinds of things that you do. You also make sure as much as possible that your hiring panels and that your decision makers are not are broader too, because there is a tendency for people to hire people who are like ourselves. It's natural human nature to be drawn to people that you are familiar with. And when you really want to have the best and brightest thinking, and this is not required by law, but this is a best practice that we often recommend to employers to try to avoid a violation of our statute, is have hiring pools that can look at things a little bit differently, and that will help your company benefit as well. This is again where the labor market studies become important. When you take a look at what happens, to people after parental leave, are they penalized for it or not? Or are they still able to move up? What does our workforce look like in terms of gender? It's hiring cases are hard to prove because we may or may not get a witness who's willing to tell us that the hiring official made that kind of comment. Certainly, if we have that evidence, that's a violation of our statute, but that's where statistics would be helpful, because if the labor market pool for women is XYZ, but the hiring shows far fewer women, then we can show a statistic, we can show through statistics that more likely than not, discrimination occurred in the workforce. But it is still a big problem. And I think that as more and more men, and this has been shown in some of the testimony that's been given before the EEOC. If you can find on our website some of this testimony, that as more and more men want to take on parental responsibilities and do take on parental responsibilities and ask for parental leave, things equalize out for everyone. And we also see this in the elder care situation as well. Women in general have been the caregivers for elder care, as well as for child care, and companies that have excellent elder care policies for men and women to take, as well as child care policies, are going to have less discrimination problems than companies that don't. So that's the preventative measure. None of those kinds of policies are required by law, but they can help prevent a violation of our law, or they can help show that if an individual came forward and said, I was discriminated based on XYZ, maybe they're not credible in that. Maybe they were, in fact, a poor performer because the company does, in fact, have good policies and procedures. So companies that have good policies and procedures can defend much more easily against unfounded claims of discrimination as well.
And I guess just out of curiosity, what do you believe, based off of your experience, are the most common forms of discrimination that you're seeing, at least in present day?
The most common form of discrimination is retaliation, which is, I believe I have been discriminated against on the basis of my race, religion, color, sex, whatever, and I complain to my employer, and then my employer gets ticked off that I complained and does something against me, like doesn't give me the promotional opportunity, takes me out of a training program, gives me a bad evaluation that means I can't get an award. The retaliation for complaints about discrimination are the biggest problem that we see. And that doesn't, a person, doesn't have to have a valid complaint of discrimination. They just have to have a good faith belief that they were discriminated against. And, but employers, sometimes it's the bad aspect of human being. They don't like to be accused of anything. And so they retaliate. So that's the biggest problem. Race discrimination continues to be a huge problem in our country, and harassment on all of the bases is a problem. Sex harassment continues to be a huge problem. I can't tell you how many cases we continue to see where there are nooses or KKK or swastikas displayed at the workforce, or the N-word is used. I cannot tell you how many sexual assault cases we continue to see at the EEOC on a daily basis walk through our doors. And then there's still a tremendous amount of the subtle forms of, which I call them subtle. They're not subtle to the people who experience them, but the failure to hire for the kinds of things you're talking about, Martina, based on, there's a stereotype that women are going to have kids and not come back, or won't be available when we want them. We have some cases where we have job segregation. We're looking at a case right now. It's a factory job, and so women are put into this one job that on the assembly line, where they decided that it requires finger dexterity, and women have smaller fingers, so they should have that job, but only men can work in shipping and receiving, because only men can use a forklift to lift heavy objects up. And it just so happens that the folks using the forklifts are getting paid more than the folks using the finger dexterity. So we still see those kinds of job segregation issues quite a bit as well.
I have two quick questions. First of all, I want to say thank you. This was so interesting. I really appreciate you doing this with us today. My first question is, I just feel like pay transparency would be such a great way to overcome the pay equity issue. If companies had to be transparent, even private companies, on what they pay. Has that issue ever been explored?
Yes.
And then my second question is, I know our time is really winding down. I'd love for you to talk a little bit more about the importance of mentoring and
Great.
getting mentors.
Great. So the answer to your question about pay transparency, that is certainly an issue that is getting lots of coverage, and there's been some folks raising that as an issue before the EEOC, which is one of the reasons why there was this debate as to whether or not employers were going to have to start reporting their pay data to us so that we could take a look at that. So that is an area of controversy. It used to be that employers would tell you that you could not talk about your pay to somebody else, and that if I told you what I was getting paid, my employer could fire me for disclosing that, because they felt it put them at a competitive disadvantage for negotiating wages, because I might be able to lowball that person if they don't know how much you're getting paid. And there are some studies that show that women and men negotiate differently for pay. So there are some state and local governments that are saying that that's illegal to prevent people from talking about their pay. We do not have a specific statute which says that it's illegal for an employer to prohibit you from talking about your pay, but we do sort of take a look at it as to whether or not it's a retaliation against somebody, because if I'm trying to find out about what other people are getting paid to make sure that I'm not being discriminated against, is that me engaging in protected activity under our statutes? So we would look at it from a retaliation point of view in analyzing our statutes, as well as, is it only people of one classification who are getting penalized for telling about their pay? Like, for example, if men got penalized because they talked about their pay, but women were allowed to talk about their pay, then it might be a sex discrimination claim. So yes, it's definitely an area that's getting broader consideration, which I think is helpful. And there are some courts that are saying that companies cannot have a blanket policy prohibiting their employees from talking about how much they're getting paid. And as for me, so I am a firm believer that I will tell you that every single job I have ever gotten has been because of networking. Every single job I got was in part because, and this also can feed into discrimination. If you're just hiring people who look like you, but it can also be different too. So every single job I have gotten in part because of somebody I know. Even when I was at Eastern, I worked at the Baskin Robbins across the street from campus because I used to go in there as a customer. I got a job working for the Alumni Association because I was in student government and had been on a committee with the person who was the head of the Alumni Association. I got a job working as a receptionist in the dorm because I kept talking to the other person who worked at the reception job in the dorm. So, and I told you about my law firm job. So the law firm job I got was in part, I knew about it because it was another Eastern Michigan graduate who happened to go to law school, who was a couple years ahead of me, and I knew her from student government, and she was working at this firm, and I needed a job, and I knew that they paid a lot of money and hired law students, and so I did everything I could to get a job at that law firm, which was great because they made me a partner the day I passed the bar. And I told you I wanted to do labor studies, but the job market wasn't available at that point in time. But the person who had founded the firm had been involved in UAW. He had been a factory worker and a union organizer and had been very active in UAW Local 600. And he was the senior partner, and the other senior partner was a woman who had been a member of the teachers union. So they were doing personal injury, but they had come out of the labor union movement. And that was also one of the ways they got cases, was because of what their connections were with the union. When I wanted to move to New York, our firm in Detroit had been a national firm, and we did lots of education. And I was very active in different bar associations and professional associations. And I did writing for those organizations. I did speaking for those organizations. One of the things I made sure to do as a new person was sit at the table when people came into a conference to give them their name tag and their materials so that they knew who I was. You know, hundreds of lawyers would come into this legal conference, and I was the volunteer at the table as a student, handed them their stuff. They knew who I was. And even as an attorney being involved. So when I wanted to come to New York, I answered a blind ad in a newspaper for a job in New York. And it just so happened that the person who had placed the blind ad, who did not use their name, happened to have been somebody who had come to my law firm seminars and heard me speak. So that's how I got hired for my first job in New York. I got hired for a job at the EEOC because my spouse at the time had gone to law school and then worked briefly in private practice with somebody who was a supervisory trial attorney at the EEOC. And I had met that person at a party once. And so when I applied, my resume got raised to the top. I hadn't been working in labor and employment law. I'd been doing personal injury law for 17 years, but they needed somebody with litigation experience, and they would never have looked at my resume if they didn't have some other connection, you know, some way of knowing me. And I believe in paying back. So I have lots of interns who come with me who I have stayed in touch with over the years. And I encourage everyone to get very active in as many outside activities as you can and do the work of meeting other people. I also believe, I strongly believe that, our country is great because of all the different kinds of people in our country. And so one of the things I have to do is I have to look at my social media accounts, and do my social media accounts look like me? Am I the only kind of person who appears on my LinkedIn account? Am I the only kind of person on my Facebook, my Twitter, my TikTok, my whatever, my Instagram? Or does my friend list, and I'm talking about real friends, not just digital friends, do they actually look like the world around me and the world that I want to go to? And that's very important to me. There needs to be an age spread. There needs to be a race and national origin spread. And I need to have those kind of contacts and communications with people, because it helps me grow as a person. And then I can, I remember that people, gave me a chance. And so I give as many people a chance as I can. So it's the pay it forward while still constantly broadening the network. Always broaden the network. It always helps you, and always be the one to volunteer to write the article for the blog, for the newsletter, to host ABC, to be the Zoom tech host, to do whatever you can to be of service. Because if you are of service, you not only help the organization, but you help yourself learn and grow. And I've also always believed in stretching myself beyond what I know. So one of the first things that I started doing at the EEOC is, I hadn't worked on an equal pay case before, but they needed a speaker at a program. So it's like, okay, I'll volunteer to be a speaker at the program, which meant I had to come up to speed to be an expert on the Equal Pay Act to go talk at that program. So you push yourself. And my spouse used to always say, fake it till you make it, and not in the phony way, of fake it, not to be phony, but believe you can do it. I sort of translate that now as to act as if, you know, I wanted to come to New York. I found a way to come to New York. I wanted to get into labor and employment law. I started making informational interviews with everybody I could to find out what was happening in the industry. How did they get into it? I did not, when I did informational interviews, I did not ask a single person for a job. I did not ask a single person for a reference. I asked them about themselves, and people love to talk about themselves. How did you get into this? What recommendations do you have? What do you like about it? What are your challenges? And do as many informational interviews as you can without ever asking them for anything other than to have them tell you how great they are. And then you will learn from that. And then maybe they will remember you when something comes open. And I mean, you just never know. I became the direct. I left the legal side of EEOC to become the director, in part because on the first day I started at the EEOC, my cubicle was across from somebody who was an administrative judge who then went on to become the director. And then when he became the director, he brought me as his deputy and groomed me to be the director. So, it's networking, and doing it for the others who are around you, next to you, and are coming after you. So, the other thing I would say is that for me in civil rights, and as a lawyer, the law is never settled till it's settled right. It's never right until it's just, and it's never just until it serves society to the fullest. And I am a citizen of this country. And, I work down near the Statue of Liberty, and that's my background photo. And I so believe in the hope of our country. And each of us here today is a citizen of the world and a member of this society. And each of us can not only advance ourselves so that we can do good for ourselves and for our families, but so that we can make a better world for others. So I really appreciate the opportunity to talk to each of you. And Eastern is a great place. You're getting a great foundation, and I know all of you are going to go on to do great things.
What a wonderful ending, Judy. Thank you very much.
Thank you.
It was truly an honor to be hosting this event and having you in front of our students. We enjoyed your speech. We enjoy you answering our questions. Thank you very much one more time from the bottom of our hearts. Thank you very much.
Thank you. Good luck to you all.
Yeah. Thank you very much.
Bye-bye.
So this concludes our event. Thank you very much.